The broadcast of the regular meeting of the Police Conduct Oversight Commission Policy and Procedure Subcommittee will now begin.
Good evening. Welcome to the regular meeting of the Police Conduct Oversight Commission Policy and Procedure Subcommittee for May 27th, 2021. I'm Abigail Sarah, the chair of the subcommittee, and I'm going to call this meeting for May 27th, 2021 to order. As we begin, I will note for the record that this meeting has remote participation by commissioners and city staff as authorized under Minnesota statutes, section 13D.021, due to the declared local public health emergency. This meeting will be recorded and posted to the city's website and YouTube channel as a means of increasing public access and transparency. This meeting is public and subject to the Minnesota Open Meeting Law. At this time, I will ask the clerk to call the roll so we can verify a quorum for the meeting.
Commissioner Abdi. Commissioner Sylvester.
Present.
Here.
Chair Sarah.
Here.
There are 3 members present.
Let the record reflect we have a quorum. Next, we'll proceed to our agenda, a copy of which has been posted for public access to the city's Legislative Information Management System, which is available at lims.minneapolismn.gov. There is an update to the agenda. In item number 5, we will switch the order of speakers. Mary Ellen Hang will speak first, and Professor Alexandra Natapov will speak second. With that update, the first motion is the adoption of the agenda. May I have a motion to adopt the agenda?
So moved.
Will the clerk please call the roll?
Commissioner Abdi.
Aye.
Commissioner Sylvester.
Aye.
Chair Sarah.
Aye.
There are 3 ayes.
That motion carries and the agenda is adopted. The next item is the acceptance of the minutes for the meeting of April 22nd, 2021. May I have a motion to accept the minutes?
So moved.
Will the clerk please call roll?
Commissioner Abdi.
Aye.
Commissioner Sylvester.
Aye.
Chair Sarah.
Aye.
There are 3 ayes.
That motion carries and the minutes for the April 22nd, 2021 meeting are accepted. The next order of business is the acceptance of public comments. I will open the floor and invite comments from the community. We will limit the public comment period to no more than 2 minutes per speaker at this time. Also, I will open up public comment again following the presentation of the 2 speakers. With that, are there any community members on the line who wish to address the commission? Please press *6 to unmute yourself and please state your name for the record. Does anyone have a general public comment? And there will be an opportunity for comment after the speakers if you do not have a general comment at this time. Please press *6 to unmute yourself. Hearing no comments, I will move on with the agenda. New business. Item number 5, misdemeanor arrests and prosecution in Minneapolis. We'll start with a presentation by Deputy City Attorney Mary Ellen Hang. Deputy City Attorney Mary Ellen Hang is the director of the Criminal Division of the Minneapolis City Attorney's Office, and she's a champion for criminal justice reforms such as the Diversion Program and alternative courts. We really appreciate her engagement and thank you very much for being here, Attorney Hang. Please take it away.
Thank you, Chair Sarah. Yes, my name is Mary Ellen Hang. I have been with the City Attorney's Office for, it will be 24 years in July. I started as a line prosecutor, became a supervising attorney in 2009, and I've been the criminal deputy since 2012. And as the deputy, I've had the opportunity to really move our division forward and be a leader in criminal justice reform. And I'm really excited to kind of touch a very high level on some of the things that we are doing in our office. As many of you know, we prosecute adults only, so individuals 18 and over, and we prosecute all petty misdemeanor, misdemeanor, and gross misdemeanor offenses that occur in Minneapolis. Just to give you a rough idea, back in 2013, our caseload was around 24,000. The last 2 years, it's been about 10,000 to 13,000 cases. So our caseload has steadily dropped, which I think is a good thing. And we receive our cases both as law enforcement makes misdemeanor arrests and do what they call a tab charge. We also prosecute offenses charged by citation, and then we issue some cases by criminal complaint, misdemeanors and gross misdemeanors. What I'm going to focus on is a lot of our work around our low level, what we call livability offenses. We do prosecute domestic violence and DWIs and those public safety cases, but the real reform work that we've done has been around these low level livability offenses that impact not only the individual who's brought into the system on these cases, but our communities that my office represents. What we know is a lot of these offenses are driven by underlying issues: homelessness, mental health, chemical addiction, any combination of that. So we've tried to find some unique ways to address that. We also know that some of these offenses are committed by individuals who are probably not likely to come in the justice system again. They've made a one-time mistake, and we're trying to lessen the collateral consequences that we know come from people that happen when you get any type of a criminal conviction. It can affect your ability to get a job, get housing. So the first thing I'm going to touch on is our diversion programs. And the first few that I'll just briefly talk about, they're aimed more towards those individuals that aren't going to be circling back in through the system. They've made a mistake, and we're trying to allow them a way to be accountable for that mistake, but not have a lot of collateral consequences and possibly have a conviction. So we offer diversion both pre-charge and in court after they've been charged. Pre-charge is just what it sounds like. If they agree to do our diversion program and are successful, we never file that case. That's the best case scenario. If the case is filed and they're eligible, they can do it usually as part of an agreement to suspend prosecution. So there's no conviction, and the case is dismissed once they complete the program. We have a restorative justice livability program, and that focuses on livability offenses like public urination, minor consuming in public, possessing drug paraphernalia, those types of offenses. It's with restorative justice community action, and the individual meets with community members. They do a community conference. They talk about the offense and its impact, and they work out some sort of community service reparations agreement that the individual follows through with. We have a shoplifting diversion program, and it's exactly what it sounds like. For individuals that are charged with shoplifting, they take a class which covers both theft and shoplifting, as well as some kind of life skills. They perform some community service, and again, that charge gets dismissed. We have a fairly new program we call Interact, and that is for individuals that are charged with misdemeanor obstructing legal process. They've somehow been charged with interfering with a law enforcement officer, but not with any level of force used. It's fairly unique, and I honestly don't know how this program will go kind of after what's happened in the last year with everything with the death of Mr. Floyd, but it was a unique way, I think, for us to address these crimes. We ended up trying a lot of these cases. We didn't win them. There really wasn't a good result even for the individual charged. So what happens is restorative justice community action facilitates this for us, and a higher level representative of the law enforcement agency, an MPD, they've been kind of trained in by RJCA on how to do this interaction. They sit down with the individual charged and they talk about the offense. The individual gets a chance to talk about the offense from their perspective, why they did what they did, how they felt about what the police officer did. The officer is going to talk about it from the law enforcement perspective, maybe try to explain why the officer did what he or she did. They will acknowledge if they think, the officer could have done something different, and they have a dialogue about that. And hopefully both sides come back with a better understanding of what happened, why it happened, and what we can do better. On the law enforcement side, that we do not have the individual officers involved do the facilitation, but they get feedback from this and follow up. And so far, the participants have completed surveys for us, and the feedback's been very positive. They feel like they got a chance to be heard, to talk about the offense, and many even indicated they have a little bit better understanding about the officer's perspective. So we think it's a really unique program to kind of address those types of cases. And then we're an active participant in the driving diversion program, where we're trying to help individuals get their licenses back. Our two new programs that they are post-conviction, but they're really unique, is we have a Pathways, we call it Pathways Diversion Program for low-level gun offenders, people carrying without a permit. What we found, I was telling Commissioner Sarah, We have a 90+% conviction rate on these cases, and the majority of the individuals we were prosecuting were young African-American males, 18 to 30. And when I looked at their recidivism post-conviction for my case, 75% were going on to commit felonies and serving serious jail time, if not prison. So we knew we needed to do something different on our cases to intervene. So we partner with Urban Ventures, and they receive a stay of adjudication on their case, and they go through about a 12-week primary phase program all day where they take classes on cognitive skills, anger management, and the key piece that's unique is it's trauma-centered. What we found is most of these young men are carrying pistols for protection because they've experienced some sort of violence in their life or to a family member, and they tell the police that that's why they have the gun. And this trauma component that they teach really seems to be making a difference in helping these young men make changes. And what we've reviewed 307 cases, 192 have been eligible. We have had 48 successful graduates, and only 9 of those graduates have picked up any sort of significant new offense, only 1 new gun offense. And so the recidivism has just completely flipped, and we're seeing long-term success. A couple of these young men who have graduated are now part of the violence interrupters in the city. They're making positive changes. So we're really proud of that program. And we just started a new program for first-time domestic violence offenders called Renew. We're partnering with North Point. It just started in January, so I don't have a lot of statistics, but it's based on similar principles, kind of a holistic, community-based approach, trauma-informed, and this is going to focus on the family as well, not just the individual defendant. And so we're hoping that this program will start seeing the success that Pathways had. The last thing I'll just touch on is, aside from these programs, my office has been a leader in trying to do some criminal justice reform initiatives. We were part of the Adult Detention Initiative, where the sign and release and book and release warrants were developed, where if a person is charged by summons and that summons comes back returned mail, when they don't appear for their court date, they get a sign and release warrant rather than a bail warrant. So when they're encountered by law enforcement, they're given a court date to appear rather than taken to jail and booked and have to post bail because they didn't even know that court date existed. We helped establish restorative court, which works with those low-level livability offenses. We've partnered with Hennepin County Health and Human Services, and the individuals work with social workers, and those social workers help them address those underlying issues. And when they do, and they are getting kind of more stabilized, then we are doing a better resolution, often a dismissal on their court cases. We reviewed the people that were successful in restorative court from 2019, and we reduced their recidivism by 69%. So we're seeing some really good results. The social workers are just phenomenal. They do great work with these individuals. We're starting to use them more and more in a lot of programs. We have the former program, the Downtown 100, which is now called the Strategic Justice Partnership. It's a very similar approach, kind of a holistic approach, but it focuses on the downtown area. So individuals charged with these crimes downtown. It started out by placing these individuals on active probation to a dedicated probation officer. That was back in 2010. And at the time, that was a unique model. And I think it worked well because it gave us some resources and some support to get these individuals into treatment and address their mental health. We added a social worker to that group. That social worker is doing street outreach and case management. We're trying to get them engaged with services without having to bring them into the court system. And that just started this year. So we're really excited to see how that impacts that program, adding that social worker component. And some of these individuals are going through our restorative court as well, rather than be placed on active probation. So we kind of have a dual track depending on what the individual needs as far as their cases. And then the last thing I'll touch on is we've been a real advocate at the legislature. We've been active in supporting the driver's license suspension bill, where we're advocating that individuals should not have their driving privileges suspended for non-payment of fines. That just adds more collateral consequences. It doesn't help anyone. It certainly doesn't help them get their license back. Doesn't promote valid licensed insured drivers on the road. That bill we're hoping is going to be passed in the special session. Call your representative or senator, encourage them to do so. And we're supporting the fines and fees bill, where we're asking that the mandatory court surcharge, which is an additional fee on top of any fines imposed that is mandatory and can't be waived, be either allowed to be waived, modified, or allow community service, because again, you're just creating a financial burden for individuals that often are low income and simply don't have the money to pay the fine imposed, let alone a mandatory court fee that goes to support the courts. So that's a really quick overview of the work we've done. I'm really proud of my staff and the work. We're hoping to continue to innovate and do more work like this over the years. And I'm happy to take questions at the end.
Thank you so much, Attorney Hang. I think I'm going to take questions after the second speaker, just so we can sort of have the full body of information. So our next speaker is Professor Alexandra Natapov. She is a legal scholar and a criminal justice expert. Her scholarship focuses on the influence of misdemeanors in the U.S. criminal justice system, and she recently published a book focusing on misdemeanors and how that impacts local communities. She's also consulted with government agencies, providing testimony and assisting in making criminal justice changes. So thank you very much for your time. We're very grateful to have your expertise. Please take it away.
Thank you. Can you hear me all right? So thank you so much for having me. Obviously, this week is a historic week. It marks the 1-year anniversary of George Floyd's murder. The whole country is grappling with these difficult issues that your commission is grappling with. We are all thinking about how to make our criminal system fairer, more effective, less racist, and less violent. And so this is a moment not only of historical significance, but also enormous opportunity. And so I want to say that I'm honored that you have invited me to be here, part of your all-important conversation in this all-important city. So as Chair Sarah mentioned, I have spent the last decade or so thinking about criminal systemic reform from the perspective of misdemeanors, from the bottom-up perspective. And I want to emphasize the importance of the work that Attorney Hang and her office do in this regard. We don't always accord the misdemeanor system the importance and the attention that it deserves. So I want to commend Attorney Hang and her office for the obvious effort that they have been putting in over the years and currently to address this all-important space. I want to encourage this commission, your city council, residents of the city of Minneapolis who may be listening, to appreciate this focus, that the low-level offense machinery, the misdemeanor machinery, as we have learned in the most painful ways recently, is a space of great human suffering, great injustice, a lot of racism, and too much violence. But it is also a place of great opportunity for change and improvement. And so what I'd like to do is take a few minutes to talk about a perspective on our criminal system from the misdemeanor vantage point, and then offer a couple of concrete changes that this commission could recommend immediately that would build upon and expand the kinds of work that your city attorney office is already engaged in. So first, to understand our criminal system, we don't usually think about them this way, but misdemeanors are mostly what our criminal system does. 80% of all the criminal cases in the United States filed in the United States are misdemeanors. Most Americans who encounter the criminal system will do so through the misdemeanor apparatus. Misdemeanors are in effect the net. This is how we sweep people into the criminal system in the first instance. It is a space of enormous discretion, both police discretion and prosecutorial discretion, and therefore, unfortunately, as we have seen over and over again, it is also a space of enormous race discrimination. People of color are stopped and arrested more often, often punished more harshly than are white people for traffic violations, for low-level conduct like loitering, trespassing, even jaywalking, common conduct in which almost everyone engages, but for which not everyone is punished. We sometimes say that misdemeanors represent the first step in the racialization of crime in America, by which we mean that this is the focusing of criminal enforcement on people of color and communities of color, and therefore represents an obvious space and opportunity, to roll back that unfair and disproportionate focus. Not only do we tend to underestimate and underappreciate the scale of misdemeanors, but we underappreciate the costs for individuals of a brush with the misdemeanor system. Again, especially for people of color who are too easily marked with misdemeanor criminal records for life. Attorneys often call misdemeanors petty offenses or minor offenses, but there is in fact nothing minor about the punishments that go with them. People who are arrested, charged with misdemeanors are losing their liberty, they're losing their jobs, their housing. If they're convicted, they will lose government benefits, perhaps their immigration status. Again, all based on allegations of relatively minor conduct. Going to jail, even briefly, as we know, can be dangerous. It's traumatizing. Fines and fees, as Attorney Hang mentioned, those fines and fees, misdemeanor fines and fees can be crushing for individuals. They push people further into economic insecurity and into poverty. Even a single arrest record can have long-term consequences for employment, of course, but also because police and prosecutors and judges treat people more harshly if they have been arrested before, even for a misdemeanor. And so in all these ways, a misdemeanor arrest, an encounter, or a case can be devastating for individuals and for their families. I want to suggest, therefore, that the best way to understand misdemeanors are not as a kind of case, but that this is a system. It's a set of processes and institutions, and that we look to see how each step of that process generates economic disparity, racial disparity, and then think how we might address that at each step. It's an enormous process. It begins on the street with stop and frisk, and then arrest, detention, jail, criminal charges, fines and fees, more incarceration. Each step of this process imposes costs, and again, each step offers opportunities for change. And so here I'd like to, as I noted at the beginning, I'd like to propose two concrete changes at two pivotal key moments in the misdemeanor process, both of which are designed to shrink that enormous misdemeanor net and to reduce its destructive individual and communal impact. There are many more interventions. Attorney Hang has mentioned a few, and I'm happy to talk about them in the Q&A, but these two, in my view, represent best practices. Many jurisdictions are already adopting them. They require no change in law. They can be adopted tomorrow. And they have the potential to meaningfully shrink this enormous and destructive misdemeanor net that we have permitted to grow, and to reduce the scale with which we sweep people into the criminal system in the first place. And so in a nutshell, the two changes are: one, police should make fewer misdemeanor arrests, and prosecutors should decline more misdemeanor cases. And I'll explain what I mean by both of those. So as we know, in the most tragic ways, misdemeanor arrests are incredibly costly. We have seen across the country as well as here in Minneapolis. This is where racial disparities in the criminal system begin. Arrests are also, however, the initiation, the beginning of the punitive and dangerous experience of being in the criminal system. They are, by definition, forcible. They involve detention and all the dangers that go with it. They involve pretrial incarceration, they create criminal records, and they create all these punitive and risky experiences, even when that arrest does not actually lead to any criminal case or any criminal conviction. And so the bottom line is that we should do it less. It turns out, conveniently, that Minnesota law in this regard is ahead of the curve. Your court rules, Minnesota Court Rule 6.01, already requires police to issue a citation rather than engage in a custodial arrest in misdemeanor cases. And so the challenge is not to change the law here, but to ensure that police actually abide by existing Minnesota law, to make it real, to put it into practice. And as you know, your neighbors in Brooklyn Center have already taken steps in this regard in response to the killing of Daunte Wright. Cities all over the country are experimenting with decriminalization, with issuing citations instead of engaging in arrest, turning to unarmed service providers rather than armed police with the authority to make arrest. And the idea is that reducing arrest is a way of shrinking the net. It's a powerful first step in reducing the violence of the low-level criminal system, reducing the incarceration that it too often imposes, and also improving the relationships between police and the communities that they serve. The second intervention, so reducing misdemeanor arrest, the second intervention is prosecutor focused, and that is to raise declination rates. And declination is a technical term. It means, it refers to the moment when a prosecutor declines to transform a misdemeanor arrest into a case at all. So that misdemeanor arrestee never becomes a criminal defendant. Or to put it differently, to recognize, it's when prosecutors recognize that being arrested all by itself is a substantial intervention. It's a form of punishment in and of itself. And that for much of this low-level conduct, that is enough. Attorney Heng described the impressive array of diversion programs that her office runs, and declination is the step before that. Rather than subjecting a person to the supervision and pressures and requirements of a diversion program, those kinds of supervision, the case itself is declined before they ever get into the criminal system at all. Unlike felonies, misdemeanor declination rates tend to be low, which is a way of recognizing that prosecutors are ratifying police decisions to arrest rather than screening them. So in effect, police are getting to decide who will be formally charged with a crime. That is not how our criminal system is supposed to work. Prosecutors are supposed to make that decision, but when declination rates are low, it means those arrests are automatically being funneled into the formal criminal system. As we know from research around the country, declination rates also tend to be racially disparate. White defendants often get their cases declined more often than defendants of color. The process in many offices is often managed by the least experienced prosecutors in the office because it's seen as a form of training. And again, at this key moment, this key juncture in the criminal process, the opportunities for improvement are enormous. And when prosecutors decline more rigorously, in other words, when they screen arrests more rigorously, there are enormous benefits for all the actors in the system. I'll just mention a few. There was a groundbreaking study came out just last month, I think, an empirical study from NYU that examined declination policies in Suffolk County in Boston. And the study showed just how salutary, how beneficial raising declination rates can be for the entire system. Not only does declination save the individual, of course, that individual from going to jail, from getting a record, from having to go to court, from paying fines, from engaging in a diversion or probationary program, but it also reduced their future criminal contacts with the criminal system itself. In other words, it was advancing public safety, even as it was producing benefits for the individuals and reducing the impact of the low-level criminal system on the residents of Suffolk County. Prosecutors around the country, from LA to Boston, have been developing policies, declination policies that establish strong presumptions of declination for certain classes of misdemeanor. Prosecutors, of course, always retain their discretion to put a case into diversion or put a case farther along in the criminal system, but strong presumptions for misdemeanor declinations are growing up all over the country. And of course, at the risk of stating the obvious, higher declination rates have the potential to save the city millions of dollars in prosecutorial time, public defense, jail costs, and court costs. Less instrumentally, perhaps, but just as importantly, the Supreme Court of the United States tells us that declinations are central to the prosecutorial role. Prosecutors are not supposed to ratify police decisions. They are empowered to check and screen them. Indeed, the integrity of the entire criminal system relies on prosecutors who are attorneys and officers of the court to perform this function. And it's one of the reasons that we accord special powers to prosecutors and have special rules for them. For example, we give prosecutors absolute immunity from lawsuit in a way that we do not give to police officers, because their discretionary role is so important. Prosecutors are given vast, unreviewable, equitable discretion to decide the all-important question about whether an arrest really warrants the opening of a full-fledged formal criminal case. And so when prosecutors decline an arrest, it's not an insult to the police. It's actually a recognition of the very different roles and the very different functions of police and prosecutors in our system of criminal justice. So I want to leave plenty of time for conversation and questions. For those of you who are interested in more information, as Chair Sarah mentioned, you can take a look at my book, which is about the entire American misdemeanor system. It's called Punishment Without Crime. For those of you who are more film people than book people, the book inspired a documentary called Racially Charged, America's Misdemeanor Problem. That film is available free for viewing and also for educational screenings. I think it behooves us to end by acknowledging that we are here in so many ways because of George Floyd, not least because he was stopped on the allegation of a misdemeanor. And so was Daunte Wright. And so was Philando Castile. And so was Eric Garner in New York. And so was Michael Brown in Ferguson. Our misdemeanor net is too wide and it is too violent. It authorizes the use of lethal police force in response to the most minor allegations of civilian conduct. And it need not be this way. So I look forward very much to your thoughts and comments and questions.
Thank you so much. Commissioners Abdi and Commissioner Sylvester, would you like to ask any questions or offer any comments?
Yeah, if that's appropriate. First of all, thank you both for coming here. This has been wonderful, and Chair Sarah never disappoints in her meetings, and this is another 10. First of all, Deputy City Attorney Heng, I got a couple of questions. I work in EMS in Minneapolis, and I think I probably run into a lot of the same people that your office runs into on a pretty regular basis, kind of in the downtown area. Specifically, can you talk a little bit, and I'm just looking for like a general understanding, how many folks do you run into in the misdemeanor system, maybe in some of these diversionary programs, who are also experiencing either mental illness and or substance abuse issues?
Commissioner Sylvester, I don't have an exact number, but it's a lot. When we're talking about these low-level, non-violent offenses, like we're talking about, a lot of them are driven by these underlying issues. The individuals have, many of the things that you're describing, mental health issues of various degrees, chemical dependency, drug addiction. They're homeless. They don't have jobs. So yes, that's a driving factor for a lot, especially the individuals that we see that continue to get cited or arrested and kind of cycle in and out. like I said, I've been doing this a long time, and our method of addressing that has certainly evolved, and I think evolved for the better, especially with right now tapping into the social workers. Like I said, has been it kind of just happened unexpectedly, and it turned out to be just an exceptional addition to the toolbox in which we have. But when we started the program like the Downtown 100 and put them on active probation, which I think isn't necessarily the right fit for these, what we kind of refer to as these low risk, high need individuals. Sometimes even the active supervision of the court often does more harm than good and doesn't lead to success. But at the time we knew they had these issues, and if we didn't somehow try to intervene and help them get the treatment or whatever they needed, we weren't going to do any good. And so, we did what we thought was right at the time, and we used probation because they can be ordered, court can order them to treatment, whether, sometimes it works being ordered, sometimes it doesn't. But we've known for a long time that for a lot of these types of crimes, that's what's really driving it. And I think we're just a lot better informed, and we have a lot more data and tools now, realizing there's a lot of better ways to deal with that than criminalizing it. And that's really, I think, what the professor's talking about. What we're trying to do is not criminalize these things, but it drives a lot of the cases that we handle, a lot.
Sure, that was my suspicion, but I was really hoping you would elaborate on that, and you really did, and I appreciate that. What's your office's relationship with the hospital systems that cover the city? I mean, I'm thinking about like Fairview and Abbott and specifically HCMC. Like, do you have a relationship with those systems? Because I feel like in my daily work, I am kind of an ad hoc diversionary resource most days for smart officers who understand that this is an addiction issue, this is a chronic health issue, whatever. And so instead of taking you to jail for something that the handbook might say you should be taken to jail for or whatever, you get an ambulance ride. So what's your relationship with the health systems?
Commissioner Sylvester, we don't have a direct relationship, so to speak, but certainly yes. I mean, we, with someone in need of either medical services or with the new 1800 service center, I've spoken to Minneapolis Police, Metro Transit, and we've encouraged them for these. If they encounter an individual who appears to be in need of services, having these issues, we've encouraged them rather, use their discretion. As the professor said, they have discretion. They don't have to cite, they don't have to arrest, direct them to those places and get them help. It is interesting though, a lot of the cases that you're talking about, they do come out of HCMC, out of the, the psychiatric, and they're cases that I don't like seeing, where you have someone who's clearly having some issues, mental health, and that may lead them to be obstreperous, and then they want them to leave and they won't leave, and next thing you know, security's arresting them for trespassing, or maybe they get violent, and now we have an assault that we know is driven by these behaviors. And we get a lot of those cases, and we're trying to put those into our restorative court and lessen the criminality of the behavior and getting them the help they need. But those cases, they're hard for us to prosecute because we understand why law enforcement got called and that, they intervened, but prosecuting that individual is not really the right answer. So, from that respect, those cases are hard. And that tends to be kind of how we interact with the hospitals, unfortunately.
Thank you so much. I appreciate that.
Okay. I was like looking at your face. I have a couple things. So first, thank you both for being here. I'm feeling very hopeful that we have something tangible, wow, this is something that could be very beneficial and could be on the horizon. So thank you for giving us this information. I am really glad to hear all the great things that the attorney's office is able to do, and sounds like it's being really successful. So on that part, how can we use all these great resources for lower offenses like misdemeanors, but for the folks on the opposite end? And how can it be just as effective? So that's my first question.
Commissioner Abdi, I'm not sure I quite understand what you're asking me. Could you repeat that, please?
Yeah, so I'm just hearing there's like a lot of like support and resources and collaboration around like misdemeanor offenses to try to alleviate them being in the criminal justice system. Is it possible? And what would it look like if we did just that, but for folks that are getting felonies?
Yes. I know that the county attorney's office is doing work in that area for some offenses. For the individuals that are charged with low-level property and drug offenses. I mean, really, the difference between a felony damage to property and a damage to property that comes to me is the dollar amount. They broke, something that's over $1,000. Depending on how much of a narcotic they have, it may be a gross misdemeanor that my office prosecutes. It might be a 5th-degree felony. And so they are starting, they've always utilized the tools of treatment and the treatment courts. They have a robust drug court, but they are starting a felony restorative court based on our model, trying to engage them with social workers. So for certain appropriate felony offenses, the county attorneys engaged in this process. And I think that's really exciting to see, because those are the areas where, again, they can really make a difference. And then, as the professor said, their resources will be better utilized prosecuting the violent criminals that need to be prosecuted. So yes, that work's being done by them, and I encourage you to reach out. Andy Lefevre is their criminal deputy, and I'm sure he'd love to give more information on what they're doing in that regard.
Thank you so much for that. And for Ms. Natapov, so the lowering misdemeanor rates just sounds very attainable, like something that could, I'm not going to say easily happen, but we could see that happening. So, but what are the stakeholders incentive to do that? To screen arrests more vigorously? Because I know that takes manpower, just hiring enough people to probably do that. But yeah, what's the incentive for the cop and for the attorney to decline more misdemeanors, and police making more misdemeanor arrests, fewer misdemeanor arrests?
Yeah, that's a great question, and the answer is a little bit different for the two institutional players, because of course their incentives are different, and so it's an enormous subject matter. But let me just pull the thread a little bit and suggest a few ways that the commission might think about it. So with respect to police, one of the things we've learned is that there are all kinds of incentives for police to make arrests that have nothing to do with public safety. They have to do essentially with advancement. There have been lawsuits around the country where police officers have sued their own departments, explaining that they are under pressure, either formal or more often informal arrest quotas without which they cannot advance. But because, for example, they are stationed in low-income communities of color, the way that plays out is they are essentially being pressured to make unnecessary arrests in precisely the communities that are suffering the most from it. And so one thing this commission might consider doing is, if you're interested in promoting lower arrest rates and a turn to citation the way Minnesota law actually already requires that they do, you might consider sitting down with the rank and file and asking them, what are the pressures that you experience, internal and external, that make it difficult for you, for example, to issue a citation or just release someone? Mm-hmm. Commissioner Sylvester, I was struck by your comment when you said that the smart officers turn folks over to you to get help. It's a lot to ask of police officers to say you need to be the smart one every time. We should have policies and incentives that are baked into their training, baked into their professional incentive structure, that they're always rewarded for doing the smart thing. And it's a way of hearing, I think, from the rank and file, from the police who may be relieved to have allies in other spaces to relieve the pressure on them to be making arrests that are not necessary and in fact would be better resolved by a mental health intervention or a health intervention or some other kind of intervention. So I think there's a lot of room, and I'm happy when we're offline to send you some links to research. There's an enormous amount of research in this space being done in all these areas, and I'm happy to share it with you. With respect to prosecutors' offices, and of course, Attorney Hang can speak more directly to the incentives in her particular office. There, again, there's research across the country in different prosecutorial offices to ask what are the incentives to charge cases that should be declined. Sometimes they are, again, they're internal to an office. Young prosecutors or new prosecutors may believe that they will be perceived as soft on crime if they're declining cases. They may feel that it's risky to challenge police decisions to arrest, that there is some professional or perhaps political cost to that. And I think it is in these spaces that conversation and allies are so important, that we need to have conversations, and there certainly have been jurisdictions that have embarked on these conversations between prosecutor offices and police departments to say, look, we're not disrespecting you when we decline your arrest. We're recognizing the power of arrest. We're recognizing the costs to our entire system, to our office, to the individual, and it's our job as prosecutors to make decisions. In a sense, we're not taking anything away from your decision to arrest. We have a different job, and then to make sure that every office has the resources, and in particular the data, to know how their office is really running. Again, I'll defer to Attorney Hang on her particular office, but one of the things we found in prosecutor offices around the country is they don't know what their declination rates are. They don't know what the racial disparities in their declination rates are because they don't keep the data. And when they do find out, they're able to make changes, for example, to assign more skilled senior attorneys to those initial declination decisions, because they know that these cases don't need to be prosecuted, whereas junior attorneys may feel, more pressure to make decisions differently. So there are, data collection. This is many prosecutorial offices are starting to collect more data precisely so they can make these kind of internal changes that we know can be so powerful, but they, but as you pointed out, they can be done now. They don't. The city council doesn't need to pass a new ordinance. Minnesota doesn't need to pass a new state law. The offices have that capacity. And I should note that there are resources. So, for example, for prosecutorial offices that want to do more data collection, there are foundations and research organizations that are interested in partnering. Often, prosecutor offices don't have the resources. They don't have the data infrastructure. That's not rocket science. Allies can help find those resources for offices that want to do that work.
Thank you. I'm just feeling so inspired by you both. Thank you so much for the work that you guys do.
And Commissioner Sylvester, you have your hand up.
Yeah, I just wanted to circle back on that comment. I guess I work with a lot of really, really smart cops, and a couple of guys the other day up in Northeast called me because some person with some significant mental illness was banging on the door of a random house looking for her son, who obviously wasn't in the house. But they called me because she wasn't wearing socks and she had these really crummy boots on and she had terrible blisters. And so instead of calling me for, to transport somebody with mental illness, they called me because you got to check out this poor woman's feet. Well, that's how we got her into the ambulance. That's how we got her into the hospital. That's how we got her into, acute psych services, whatever. So that's what I'm talking about, smart officers. And I'd like to circle back, I guess, to Attorney Hang one more time, talking about misdemeanors here, if I can. Have you seen a drop in the last, the data, the wonderful spreadsheets that I got sent here doesn't really cover the last year, but just kind of anecdotally, have you seen a drop in misdemeanors in the city in the last year?
Commissioner Sylvester, yes. Our caseload for 2020, even though it was still 10,000 cases, we had obviously two very significant events in 2020 that impacted our prosecution, and it started when the pandemic hit and the courts shut down in basically the end of March. And we were only having in custody court hearings for several months. And then slowly we only started doing jury trials on our misdemeanors again in May. And then, Mr. Floyd was murdered. And then that obviously impacted law enforcement. And so those two, yes, we saw a significant drop in arrests and citations in these. And then, and it's impacting how we're addressing these cases now, because the court system, and we're doing more than in custody court hearings right now, but we're doing them remotely. We're still not in person, and we may not likely be in person until September or possibly until 2022. So we're doing fewer cases on the calendar. And along, with the discretion, what I'm trying to talk to my staff about is, as we start doing these cases, it's going to kind of force us to exercise some of the discretion that Ms. Natapov is talking about. We have to decide, where do we want to put our resources? And as we are going to trial, we need to be looking at that repeat drunk driver, that repeat domestic abuse. We don't need to be don't need to be trying a trespassing case that's driven by underlying issues. And so it's going to factor in how we resolve our cases moving forward and how we look at them. And I think how we decline certain things. And we're already seeing it happen of like, okay, one of the things I think that my staff also does really well that not all prosecutor offices do when it comes to misdemeanors is you have to, first you have to look at the case. You have to decide, is it a good case? Is there probable cause? And if there's not, you need to do the right thing and dismiss it and decline it right away. But even if there is, it's not just looking at the individual behavior, but, assuming there's no victims involved or any public safety risks. We also do a good job of looking at their entire criminal history, because it's amazing. You might see, okay, this is a trespassing. It's a perfectly good trespassing, but they have 2 open felonies that they're dealing with. Do we really need to charge our trespass and have it tagged with that felony only to get dismissed in 9 months? And, they may have other things in other jurisdictions. And I think that's part of, not piling on and being smart as prosecutors of deciding, is this a case that we need to be taking on when they have these other things going on, or looking at, they're already on probation and they're having their issues addressed. Do we need another case? What's it going to add? So I think a lot of that goes into that analysis, looking just beyond the case and really seeing what's going on in their whole world.
So much. One more, and thank you so much for being here again, and thank you for your work in our city. One more. This year, the county with COVID started housing a lot of people in a lot of empty hotels, and in my work, on the streets, I've seen that have just a huge impact on people's lives. And really understanding that housing, you can't be med compliant with mental health issues if you don't have a place to live. And you can't be, med compliant with your diabetes if you don't have a fridge to store your insulin. And you can't go to your diversion programs if you don't have a place to plug in your cell phone in order to tell you it's time to wake up. You know what I mean?
Yep.
And so what impact do you think has that kind of sheltering program in those hotels, kind of that just very basic putting people in a place, had on kind of the misdemeanor system that you've seen?
It has a huge impact, Commissioner Sylvester, for all the reasons that you cited. Also, I think something, we often, with some individuals, we try to force sobriety on them. That's not going to work. I'm in recovery myself. I wasn't going to be forced on me. I had to make my own decision, and I did that. And I think, okay, but if they're drinking in public, it's not our jobs to tell people how to live their lives. And they're drinking legally, albeit in public, but housing them somewhere where they can have a safe place to do that, and then they're not out drinking on the street, getting into further trouble. We're seeing that impact. And it's interesting, the housing piece, I'm only really still fully understanding the impact that our cases have on it. With the restorative court that I talked about, we are doing a fair number of dismissals, but sometimes we're doing continuous for dismissals to keep the case alive for a few months. And I can't tell you the number of times we've done that. And then I've got an email from the social worker saying, Mr. or Miss So-and-so, housing finally came through, but they saw that they have this, they consider it an open case, even though in my mind it's resolved, and they won't give them the apartment because they view them on probation. So then I immediately dismiss it, and I get an email the next day, they got the apartment. And I'm just like, you know, in my mind, it's a closed case. I don't understand that view, but it's the view the landlord has, and they have that right. And so, you know, as we've been talking about, the impacts of our cases go beyond just, you know, taking them off the street where they're now no longer in public community offense. It has those lingering effects that we have to be mindful of and say, you know, that's not the, when we're trying to help them, you know, the intent is not to make things worse. It's to try to put them in a better situation. So we need to do things that help them get housed and stay housed so they have a safe place. And it's all about safety too. You know, when you're feeling safe and you're warm and you're dry in Minnesota winter, you know, you're going to do better. It's not rocket science.
Thank you. We have just a few minutes left, and I would like to open up the line for public comment. Please press *6 to unmute yourself and try to be respectful. We only have a few minutes left.
Hi, this is Dave Bicking. I really appreciate your allowing public comment after the presentation. I very much appreciate the research and perspective from the professor, and I'm encouraged to hear from the city attorney that the number of cases has gone down substantially in the last few years. Just wanted to offer a quick perspective. A number of years ago, probably 12 years ago or so, I worked for several years with restorative justice myself in the Midtown Restorative Justice. And it's certainly an improvement over the court system for handling the cases we were talking about, but that's faint praise, I'm afraid. We found that the big thing we were seeing there, in fact, most of our cases were solicitation of prostitution. It was a big sting for a number of years there on Lake Street. And one of the requirements is that a person has to admit responsibility or guilt and, understand the harm they created. Some people did exactly that and were, followed the program. But in a number of cases, it was clear that people, while saying that, yes, that they were guilty, telling a story that said something quite differently. And in many cases, I believe them. Certainly the racial disparities in the arrests were just blatant in terms of the cases that we saw. So, and many or most of those arrests should not have been made, or at least they were targeted at African Americans and immigrants of color. So the problem helped the individuals involved, but it covered up basically a problem within the court system itself. So pretty much everybody completed it. It was good. I was glad I did it, but it's not the cure-all for the system that we would like to see. The other thing quickly is you mentioned or talked about the custodial arrests versus issuing a citation. At Communities United Against Police Brutality, we hear from a lot of people. We have a hotline that people call in. We hear about cases at our meetings. And this is an issue that comes up just over and over and over again. We ask, well, why did the officer arrest you and take you to jail? I mean, this is something you should just get a citation for. And though there are cases where custodial arrest is necessary in a misdemeanor, those are the exception. But unfortunately, we're seeing a lot of cases like that. So I just wanted to pass that on. Thanks.
Thank you, Mr. Bicking. Would anyone else like to make a public comment? Please press *6 to unmute yourself. Given that no one is speaking up, I'll take this opportunity to just mention something. Professor Natapov, you mentioned that in an area that's sort of high traffic, if you will, and there's a lot of like nuisance type crimes and livability type stuff happening, that the cost of arrest and prosecution is very high, and that money might be spent in other spaces. Could you speak to maybe in what other ways? And I'll just offer this, that when I had clients in the Downtown 100 program, one thing my clients always told me, and they were downtown, is that the housing shelter at 1010 Curry, which is downtown, it closed at 6 a.m. and didn't open until I think 5 or 6 p.m. in the evening. So they had this block of time where they couldn't be anywhere and they had to urinate, and so just offering that.
Thank you. I know we're out of time, so I'll just say briefly, we're in a moment, I think we're all aware, the pandemic seems to be drawing to a close. It has been a very unusual year. As Attorney Hang pointed out, we don't really we can't understand what happens after the pandemic in terms of crime and crime rates in the same way that we can understand it during the year. And there's some indication that some kinds of crime rates have gone up. Many people think it's because of the pandemic. And I just want to emphasize this, the value of the structural view that crime rates go up and down. Crime rates go up and down in gentrified downtown areas. They go up and down in neighborhoods. The criminologists and the experts tell us over and over again, we don't really know why. We have some theories. But what we can do is take the opportunity of this moment to invest in principled change that we know will reduce economic disparities, that will reduce racial disparities, that will address what we know to be public health and mental health and drug addiction issues in our criminal system. My guess is that we will be seeing soon a lot pressure to return to some old habits in the face of allegations of rising crime. And this is a cyclical phenomenon that happens in the United States about every 15 years. We have a moment of potential reform and then people get nervous. And so, Chair Sarah, your question about how we can instantiate these commitments are, as we have all been discussing, and the commissioners and Attorney Sarah, Attorney Hang have pointed out, we can create new institutions so that people never get into the criminal system in the first place. We can, professors, we call it the criminalization of the welfare state. That's a fancy word. We're saying we're asking the criminal system to do work it is not designed to do. Sheriffs all over the country are telling us that they are running mental health institutions, not jails. If they're not equipped to do it, we can invest in a new vision of how to treat people in need, even when we could relabel their conduct criminal. We don't have to do it. And so all the innovations that we are seeing, the mental health response teams, the civilian unarmed traffic response teams, all of these are there. Commissioner Abdi, you said, we can do this. It's right there for us to do, but we should not underestimate the power of doing it and sticking to our guns, no pun intended. As people get nervous about the cost, we know what the cost, no city unfortunately knows better than Minneapolis, the cost of doing it the old way. And so I just want to say thank you again for including me in this such an important conversation. Unfortunately, the world is watching Minneapolis, and in any way that I can be helpful to your efforts, please let me know.
Thank you so much, and very, very special thanks and gratitude to our speakers this evening. We're not going to get to the last item of our agenda. We'll save that for the next week. With that, without objection, I will then again thank our guests and direct the clerk to receive and file this presentation. And seeing no further business, I'm going to delay the last item. And without objection, I will declare this meeting adjourned. Thank you so much.